To my far left, your far right, is Robert Dinnerston, who's a professor of law emeritus and former director and founder of the Disability Rights Law Clinic at American University's Washington College of Law. He taught there from 1983 to 2023. Before that, he was an attorney for 5 years at the Department of Justice Civil Rights Division, Special Litigation Section. While at the DOJ, he litigated cases concerning the conditions in state institutions for people with intellectual disabilities, psychosocial disabilities, and juveniles. From 1994 to 2000, he was a member of the President's Committee on People with Intellectual Disabilities, and he currently chairs the ABA Commission on Disability Rights and is co-chair of the ABA Section of Civil Rights and Social Justice's Disability Rights Committee. In the area of disability rights, Bob's work has focused on issues of consent, supported decision-making, and deinstitutionalization of people with intellectual and developmental disabilities. He has an AB from Cornell University and a JD from Yale Law School. Well, I'm going to turn it over to you, Ruben, to tell us more about your paper.
Thanks so much. Thank you so much for being here. It's a great pleasure to be part of this initiative. My paper is about an area that has been almost entirely, but perhaps surprisingly, overlooked, namely the connection between disability and free speech. In general, I'm positing that this is a particularly important issue, and it's important in the way it's not been for other groups. And as most of you probably know, the general argument that's been previously made for free speech was it was a tool that enabled other civil rights movements to proceed. But my contention is it's just one benefit or one important aspect of free speech for disabled people. What's more, I think that today's climate, or anti-free speech climate, has particularly negative impact on certain groups of disabled people, and most especially people with psychosocial disabilities and people with many neurodiverse conditions. These people make up a large and under-recognised population, but whom are already frequently excluded from wider society. The employment rates, for example, are very poor, as is life expectancy, sometimes even though they've got no intrinsic physical disability that would normally limit it. My contention is that a lack of free speech will undermine their social inclusion, access to basic opportunities, and because simply they're more likely to say something wrong. And the more constraints you put on free speech, the greater the risk it imposes for them. And the other way this topic is important is due to the changes that have been made due to free speech, and particularly very negative ones that have been made over the course of the last few years within wider Western society. So, if this works. I sort of in this paper tried to model the changes in free speech and set them out. And on the left of this diagram, you'll see several changes that have happened. And this is a list of, an exhaustive list of some of the key changes. Some of these arise from technological change, so the social media era. Others arise from cultural change that has happened. But the overall point is not just society's become more censorious, but the quality of that censorship. If a single conversation goes wrong, there can be catastrophic consequences for an individual. And while this chance is small, it's there, it has a chilling effect, and it has a considerable effect on potentially every interaction we have. Some of these examples include the abandonment of free speech by much of the left. Previously, it was quite easy to avoid free speech restrictions. You'd hang out with people on the left. But now that's changed. Now it's a battle between both sides. And the amount of content to be censored has grown considerably. As a censorship of objective truths, previously they were safe. These things you could talk about without any expectation of risk. Now this is a real problem, right? And it's a particular problem for people who, due to their condition, might be particularly likely to blurt certain truths out, or they need things to be clear and concrete. An element of indirectness is very hard for someone with, say, an intellectual disability, but also people with certain psychological conditions or people with certain neurodiverse conditions. Rights not to be offended, they're increasingly expansive. They have been added to anti-discrimination law, or the definitions of harassment have been modified to include them. And given how protean these new proto-rights are, and how inclined certain people are to use them against others, they amount to a heavy restriction. The overall point that I make is that these types of restrictions, they have a cumulative effect, they add up together, and you can't just treat them in isolation. But it's the shape of speech. There's a very wide locus of free speech controls. It covers a lot more speech than it used to do. And That includes speech that's risky, right? Because not the speech that's actually blocked, but speech you can't know might be blocked or punished in some sort of way. The ability to circumvent speech controls. So today's controls are a lot harder to avoid just because you can't really know what they are. They're amorphous and unpredictable, and they can have a retroactive effect. You say the wrong word just once, even where you might expect it might be allowed, you can be in really, really big trouble today. And the potential effects. There's a possibility that the most innocuous comment, or even liking a tweet, perhaps even by accident, you accidentally press a button on your phone and it pops up, that can lead to the long-term loss of income, social exclusion. And the point is, someone who did something relatively trivial like this would have the possibility of relatively easily moving on. Now they can't. So I'd say that issues are extensive. I mean, you could write a book about the list of them, but I've grouped them into 3 categories. So first, there's disability rights in general. Today's anti-free speech culture has had a range of consequences. It blocks progress. Disabled people need it far more than any other group today. The employment rates are atrocious, life expectancy is poor, social exclusion is atrocious. There is no other minority group that is remotely as discriminated against as disabled people. And yes, it varies from that. But the point is, disabled people really need it. And blocking free speech is presently used by relatively fringe causes that like to keep things the way they are. There's a reason why institutions prioritise the performative. They prioritise land acknowledgements. They prioritise pronouns. And to pick a disability example, they prioritise jazz hands rather than clapping. That's apparently a great innovation for disabled rights. People who actually need jobs, people who need food, need some sort of opportunity to be included. That's the performative things that they like to do. It sort of really suits certain corporate types that like to maintain power, who'd like to avoid more difficult obligations like making reasonable adjustments. With effective free speech, these proto-causes, these objectively very small causes that have been given great prominence by institutions, they can be moved out of the way by sharp criticism, as they justly deserve. They rely on free speech restrictions to operate. Secondly, the special risks of vulnerable people with disabilities. In Australia, there's a Royal Commission about the sustained abuse of disabled people. This is a common thing for disabled people to be locked away in institutions today and to be abused, or even if not locked away, to be abused, say, in their schooling or whatever. If you don't have a free speech climate, how do you challenge that? What about whistleblowers? So on and so forth, right? That's one example. But also, these tools can be weaponised. These anti-free speech tools can be also weaponised against individual disabled people. They can, because they're vulnerable, right? They might not remember exactly what happened, so therefore they're less able to defend themselves. Or they accidentally slip up, or someone tells them at school as a joke, oh, you can say this, right? There's lots of different subtle ways that people with disabilities can be made vulnerable, and especially people with social disabilities. And I would say that, most notably is the impact on people with psychosocial disabilities and neurodiverse conditions. I've been deliberately quite broad here, but there's a whole range of conditions that are affected, and you can't make a definitive list because a lot of these people are individuals, and the conditions are very individual specific. But first, how are these people supposed to know what the rules are, right? If they don't know what these rules are, how are they not more likely to transgress the relevant lines? And even if they know what the lines are, do they have the ability to comply with them quite often? So these demands that are being put on them are likely to be very difficult. They're especially cognitively demanding to comply with, and the cognitive dissonance that goes with that. As some neurodiverse people put it, complying with social expectations is a form of torture, right? And now we've just added a massive pile of social expectations and rules to them. It doesn't bode well for their inclusion in the workplace or other aspects of society. Second, but more subtly, there's a loss of access to information, right? Some of these people need things saying directly, this is it, with a certain bluntness, right? That ranges from intellectual disabilities to other groups, right? But there's also a need for certainty. We're taking away certainty. We're beating about the bush. It's not a good thing. But also, some people are less likely to want to talk to them because of the risk, right? What happens if they repeat something you ostensibly said? And then there's healthcare. If you take away objectivity, then you promote distrust. This is a problem for people who are naturally suspicious, a common issue with people with many neurodiverse and psychological conditions. And there's a gap in life expectancy is enormous, right? It's not just whether they go for surgery or something, it's like whether they brush their teeth, what diet they should have. Those sort of things, and they make poorer decisions, and they need, obviously, concrete advice. So, what's next? And in the interest of brevity, I won't go through all this, but my key point is that a free speech culture is an anticipatory reasonable adjustment or accommodation. And I think this is an exciting new legal agenda. It supports free speech by expanding its scope into a duty that applies to private organisations, as well as providing a moral basis for free speech. But it also looks at providing a more inclusive society for disabled people. And I conclude the paper by looking at future directions for discrimination law and how it should be recalibrated. And this is a story of a more sophisticated set of arguments than what appears on that slide, naturally. But you consider the very recent case of Carborg Neil in the UK. He said one word wrong, and he was out. Due to dyslexia, he got confused over words, and he accidentally said the wrong word. And the result was basically to destroy his life, destroy his career, destroy his livelihood. And that's, we probably need to be rethinking about a balancing of things like hostile environment laws, harassment laws, because they do have a very negative effect on neurodiverse people, and they came about before these people were recognised and before there was disability discrimination law. And so there's a longer discussion to be had about how we reconceptualise discrimination law in light of disabled people's needs and the current free speech climate. I'll rest there, but I'm looking forward to discussion and hearing from my fellow panellists. Thank you so much.
Thank you. Duran, I will let you.
Oh, am I first? Okay.
Yeah.
So, first of all, I want to thank everyone for coming and for inviting me. And I also want to thank Ruben for getting a disability story into a space that usually doesn't maybe think about disability. I don't think anyone in George Mason, I don't want to put you, on the spot, but I don't think anyone teaches disability rights. I've been doing it for 15 years. I'm actually non-American, so I can speak to disability rights globally. And I want to cite from a very famous author and his famous book, Joe Shapiro, and his book, No Pity, which traces the disability rights movement and the independent living movement in the US. He says that every story has a disability angle to it. And I think what Ruben is trying to do is to bring the disability angle into free speech. And I think that's commendable. What I find a little problematic about the paper is that I don't see enough evidence and I don't see enough stories to tell me that this is actually a problem. So I think Ruben mentioned the Seaborg case from England. I was not familiar with this case, but I actually looked it up after reading the paper. And Ruben actually pointed out, and rightfully so, that in that case, the person who was autistic actually won the case. I would think, and I think that is a matter of your stance, that a lot of tribunals, a lot of courts would actually side with a person with disability about the slip in language. And so I really don't see this as a problem that arises on the everyday for people with disabilities. Now, I might be incorrect, and I obviously don't know about every person's experience, but I know Ruben is doing empirical work, and I do too. And people who follow my work know that I work on suspicion against people with disabilities, about faking a disability. And what I do is I run surveys and experiments, and I also do qualitative work. So I interview people with disabilities, and I go and I do observations. And what I would like to encourage Ruben to do is just that, and to bring a little bit more stories and narratives that will convince me that there is really a problem here, that it's not a theoretical issue that just flows around, and to think about that a little bit more. I would also like to give you a little bit of a pointer. I have a very good friend called Mason Marks at Florida State University, and Mason wrote a paper years ago about speech on the internet, and talks about self-harm and how is that being censored, bless you, censored by Facebook and other social media moguls. So that could be like an angle. It's just, I would like more narrative, I would like more testimony, I would like more evidence before I decide this is a real big problem. Another really interesting issue is about language. So I actually agree with Ruben about a few things in this paper. And I do agree that a lot of the time in disability, rights, especially in academic discourse. I'm not sure if it happens on the everyday, but Bob will. Also, it's an honor to be here next to Bob, who I admire. So congratulations on your retirement. I wanted to say that and I forgot. In academic, if you ever try to publish a paper on disability, which I've been doing for a very long time, you will sometimes get a comment to tell you, don't say disabled people. We use person first language, right? So say people with disabilities. Whereas actually in reality, there's disability communities as much as there are Black communities, right, or Latino communities, and there's a lot of people who prefer different languages. So I agree with Ruben that there is an issue sometimes with language and naming, but that is to me more in an academic discourse. And and I do, and actually there are really great papers about that. So Robin Powell wrote a great paper about that, and I'm happy to share more with you. But to me, it's not something that happens on the everyday. I do think it's worth pointing out, but it's not something that happens on the everyday. What I found really interesting about this paper is that it uses the word neurodiversity, which is an encompassing word that maybe some of you did not hear before, but it's actually basically was first established in the autism community. Now, what's really interesting is that actually people with, people in that community actually like to be called autistic, right? So I thought it was really interesting, right, that there's this dancing around the world, a word that a lot of people actually take pride in. So I think to me, and again, I don't want to say I'm not a free speech person, because who's not a free speech person, right? I'm into free speech, but I don't research free speech for a living. I research other things. For me, this dancing around words is something that is worth pointing out to, but it should not be a moral panic. It should not be a source for moral panic. It should actually, show me that this is a real problem. I would just want to say, two things that bothered me on two pages, and I'll be a little specific, but I think it's important. There's a sentence that says, one must remember that the goal is not necessarily to give disabled people equal lives, but reasonable ones. I disagree with that statement, and to me, disability law is an equality law. To me, the goal is to get equality for people with disabilities, and the tool to get it is reasonable accommodations. So I think there needs to be a little bit more of understanding of some ideas. Another one is about the choice for accommodation. So this is true that when you give reasonable accommodations, you should not, that the person with a disability does not get to decide what is the best accommodation for them. However, there is an interactive process in the US to determine reasonable accommodations. So I think a person with a disability does have a say on what accommodations actually are warranted. So that's another important, I think, point. One last point that I would want to make is also about this issue of reasonable accommodations, and it might come up later as well. To me, this, the use of the word accommodation here might not be the best one. I would think of it more of as a defense in criminal law, right? You have an insanity defense, right? An accommodation is something that is very individualistic, and I have 3 minutes? Oh, okay, I'm rushing through it, and I actually have some time. An accommodation is something that is individualistic, and it's something that is, I'm sorry for the legal jargon, but it's ex post and not ex ante, right? So it's something that kind of occurs after a person actually asks for it and after it is put in place. It's not something that is ex ante, at least not in American law. Now that should be criticized, and I in fact wrote about it in terms of accessibility in urban spaces. So a lot of the time, the request or the requirement for making a place accessible comes after the place was actually erected or where the tower was already erected. But there are certain municipalities that require it beforehand, so ex ante and not ex post. But that's not an accommodation, right? That's another type of requirement. So I think that is also an important message that I would like to say. I think I also a question that I would have for Ruben is, who's the audience of this paper? And the reason I'm asking is because this paper really goes and talks about American disability law, and then it talks about the law in England, and then about the law in Australia, and then about the UN Convention on the Rights of People with Disabilities, which is an international law treaty. And it goes and it takes all of those together and kind of like, puts it into one pot, where I actually think that there are some differences between all of those. I'll stop there because I'm sure, and I'm looking at my notes to see. I will say one last thing. Just because I'm a health law scholar and I write specifically about a lot of topics with regard to doctors and people with disabilities, I have an upcoming piece about doctors who refuse to mask as an accommodation to accommodate patients with disabilities. And there is this idea about distrust in the medical profession that might arise as a concern. I think that arises more because of misinformation in the medical profession and a lot of the situations we saw during the pandemic. And I think, again, in order to be convinced that this is a culture of free speech that actually causes the marginalization of people with disabilities in our society, I would just need to see or hear a little bit more of actual stories and actual narrative and actual evidence to that. Thank you so much for bearing with me.
So Joanne mentioned and obviously properly acknowledged how far Ruben came to come to this conference from Australia. And I'm the other side of that since I came from Bethesda, which is just, for those not local, is pretty close, which doesn't mean that I don't necessarily get lost every time I try to go into this part of the Northern Virginia. That said, I'm pleased to be here, and like others, I want to thank those who organized this symposium for this really interesting day, not only on this panel, but for the whole day so far, and I'm sure for what's to come. We didn't quite say this, but I think we should to give ourselves a little credit, including Ruben. Ruben's paper is 90 pages long. When I heard this morning that I think one of the papers was 20 pages, I said, well, why didn't I get that paper to comment on? Because it was very pleasant to read it, but 90 pages is why I retired. I liked many things about this paper. It's an ambitious paper, not just because it's 90 pages, and I think as Duran alluded to, it covers lots of information, both about free speech and about disability and different jurisdictions, so there's a lot here. Though I disagreed with a number of its conclusions, and I will talk about that. I would think the main issue, and I think, again, it's somewhat consistent with what Duran said, is I don't know that, to me at least, that the case has been made sufficiently that people with disabilities are particularly vulnerable to challenges of free speech and to limitations on it. That doesn't mean that they don't benefit from it, so I don't by any means think that they should be excluded from pro-free speech environments, far from it. But I don't know that the specific aspects of disability make them particularly vulnerable, or at least I think it's a little more complicated story than perhaps has been presented. One of the things that the paper does do, which I think I found interesting because I didn't know about it, and I've now been reading up a little bit since reading the paper, the 90-page paper, is the concept of, which I think is both in the UK and in Norway, of anticipatory reasonable adjustment, which was actually part of the title here. And what's important about that, as I understand it, is that it requires the as they call the duty holder, the person who runs whether it's say the public accommodation or whatever the service is, to accommodate people not based on their individual characteristics, but on the assumptions that they are part of a group that would be subject to discrimination unless they address the barriers that are there. That's very different from US law, and I think, again, Duran kind of alluded to it, which is very focused, especially in the ADA, on discrimination against individuals with disabilities, which requires you to demonstrate not just that there's been some kind of adverse thing that's happened to you, but that you are the kind of person who the Congress understood to be within that umbrella of people to be protected here. And so it does fit more with a concept that is similar, I think, in the United States, which is, again, alluded to in the paper, called universal design, which looks to say, as we devise environments, both the built environment and the attitudinal environment, we should remember that in our midst are people with disabilities. So, the curb cut that allows the wheelchair user to be able to navigate the streets of our city is available for that person. It's also available for parents with kids who have in strollers. It's available for runners who don't want to move around. And those kinds of solutions, which don't seem as either or, have tended to be, I think, more likely to be sustainable and accepted. And so I like the concept of it, but I think with regard to applying it to US law, and again, this goes to a question of Ruben's focus, or the focus he would like, I think that has to be kind of built out a little bit more than is here. And so a couple of other thoughts. Again, I think the paper recognizes this. There's not a lot of case law on a number of these things with regard to the suppression of speech. And I will say that I did not look up the UK case as Duran did, but I did look up a US case that was alluded to, and it was about somebody with epilepsy in the workplace who was fired. And I didn't see it as a speech problem. I saw it as that he apparently lied about why it is that he fell in the workplace, and then later was kind of called on it and was let go for that, not for his disability or for what he said. It actually was nothing about his speech, but because he had misstated something that was important. So I do think that in looking for evidence here, it is important to see, well, just, again, is this a problem or a specific problem that needs to be addressed? And I think that and working a lot with people with disabilities, as I have over the years, and also having a sister with an intellectual disability, I think the issues about their speech are a little bit more complicated than the paper presents. For example, I think in many instances, people with intellectual disability, it's not that their speech is that they're jumped on for saying things, it's that they're patronized. They're told, oh, isn't that nice, this person with intellectual disability, or older terms that we now don't use, like MR. They said this thing, let's pat them on the head, that's nice, but let's ignore them. They're not really part of our community. They may live in the community, they're not of the community. And that I have found in circumstances, whether you're on a board of directors with self-advocates or people with disabilities or not, is something that you have to kind of worry about. And it's a little bit like the phrase used, I think it was by George Bush, I'm going to get it wrong, but it's basically so it'll come back to me when we come around on the second time around. But the bigotry of low expectations is what I'm saying. So we don't expect much from people with disabilities. We don't get much from them. We kind of ignore them. And we also, as was said earlier, deal with them in this paternalistic way, a way to protect them from things. So in that sense, I do have some sympathy for, again, a more robust kind of exchange where, in fact, you interact with people with disabilities and don't just assume that everything they say is okay because it's from them, but you actually help guide them. And so one of my examples is, if you're at a board meeting and you're on an agenda and you're going through it, and you have a person with intellectual disability who raises an issue that really isn't germane at that time, rather than just saying, let's let him talk, we don't want to offend him, and say, well, Johnny, that's a great idea. Can we wait till later in the agenda? We'll come back to it, of course, remembering to do that, and guide the person. And I think that actually makes a big difference. The other thing, and Ruben alluded to this in terms of institutionalization, which is still a very big problem in this country and as he indicates, in Australia and many places around the world. The reasons why people with disabilities may not speak in certain circumstances is not so much that someone is suppressing their speech or that they're going to say the wrong word, but they're in a position where they have little power, and they are dealing with people who are their supervisors, their caretakers, the people from whom they get services that they need, and they're worried. They're worried that if they say the wrong thing, not that somebody is going to kind of call them out, but that they're going to retaliate against them. In my clinic, in the clinical program we have the students do simulated interviews of people with disabilities, and we give them a fact pattern, and we bring in people with disabilities to play the role of the client. So we don't want one of the students playing that role, which is something you might do. We actually want a person with lived experience. And years ago, we brought a friend of mine in, a woman named Thelma Green, to do that. And the students, the setup was that they were in the group home interviewing her, and they said, so how is it going here, or how do they treat you? And she said, okay, stop, time out. I would never answer that question if this was really in the group home and you were there, because I'd be worried that the staff would be overhearing it. Let's figure out a way where you could actually ask me that question out of the hearing of people. Like maybe let's say, how about we go out for a coffee or something like that? And so the students found that really interesting and important, and it was really part of that issue. The other reason why many people with disabilities do not speak is that the stigma associated, particularly with psychosocial disabilities, even though I think, and have mentioned, I think, to Ruben, I think his definition of psychosocial disability is much too broad, and we may come back to that. But nevertheless, it is not a positive identity in the eyes of many. Not the uniquely so, but certainly one in which people think, gee, it's not such a great thing to be saying that. If you're applying to a job, you're applying to be admitted to a university, I might think, boy, somebody who has achieved what he or she has achieved, notwithstanding the disability they have, what an accomplishment. But most folks don't want to take that risk. They don't think that information is going to be heard in a positive way. So I think that's really there. Briefly, I want to say that another thing that I think needs more development is Ruben asserts that unlike some other groups that have argued for their rights, that people with disabilities, there's less of a kind of political activism and advocacy, and it's more kind of law-based and sort of top-down. And that's not been my experience. There's a lot of terrific work. Judy Heumann, one of the most famous disability advocates who died this past year. There are many, many instances in which legal change worked hand in hand with political change, and I think that needs to be looked at as well. I'm going to stop there because I'm out of time. So thank you for your attention.
Thank you all. I think one of the interesting things for me about this paper was that I don't do disability law, I do free speech law. And one thing that doesn't come up a lot in free speech law is including people with disabilities in the free speech conversation. And so, Ruben, I'll just turn it over to you at first, but I'd be curious for everyone's responses. Why do you think people with disabilities have been not a part of that conversation with regards to free speech?
I think there's a mix of reasons. So I think that disability rights didn't come out with very violent protests in the way that the civil rights movement did. But also, disabled people have always been invisible to begin with. The issues are different. So people just may not have thought about it. But also, it's just the issues are qualitatively different, right? So we're looking, you might be if you look at it in the same way as other civil rights movements, you just start with actually how has it helped advance obtaining rights, whereas the issues I've been looking at are actually, disadvantages, accommodations, and so on and so forth. So I think it's because I've looked at it from a different angle, but also people don't generally think about disability rights that much anyway, right? You go to a university, they're more concerned about whether someone's using the right pronouns or whether there's the right Atlantic acknowledgement at the start of the event. And I went to a online human rights event recently, and they had about, within 2 hours, 8 different land acknowledgements, but they weren't meeting the most, this is supposed to be human rights, and they weren't meeting the most basic accessibility standards of an event. So partly people just don't think about it. I think that would be my take on it.
I just want to echo what Bob said and just comment on this. There's a really big and important comment by an historian, a disability historian, that says that disability is everywhere in history, you just need to look for it. And I also want to say that the disability rights movement and is actually very important and has been very crucial, very prominent in American history. The Capitol crawl before the ADA, or the 504 taking of the San Francisco building of Health and Human Services in the 70s are really important instances in our history. And I do agree that they are marginalized, but I also think that they are important and they are actually taught more often nowadays. And I thought Bob also wanted to say something about that.
Yeah, well, I just also would add, and again, it was a point that Ruben made in the paper, that part of the problem with disability can be that the word covers so many different kinds of conditions. Conditions you're born with, conditions you acquire, intellectual, cognitive, sensory, physical. And there are situations, for example, of what kinds of accommodations people need may change quite differently depending on which disability you have. But what I do think is probably under-recognized in the paper is that there's been a lot of movement towards coalition building and consortia and other organizations that have recognized, this goes very much part of the ADA story, gee, if we're representing deaf people and they're representing blind people, we are going to get more out of our working together. Again, you could make that argument that that's actually, again, a pro-free speech, pro-exchange of ideas kind of thing, which I think is important. It doesn't mean there aren't some people who are, more inclined to marginalize their colleagues, but I think there is some sense that as Jonathan Rauch said at lunch, if you're on the outside, if you're on the margin of those things, you have to build coalitions, and because no one's going to give you that power voluntarily. You're going to have to fight for it. And I think and the last thing I'll say about why speech is important, I think, for many reasons. For people that I've worked with, for people with intellectual disability, the important thing for speech, not still now, but particularly like 10 or 15 years ago, was we want out of institutions. That's what has to end. We don't want the use of the R word. We find it offensive. And people spoke out quite a lot about that because that mattered to them in their daily lives. And so maybe less interested in the kinds of speech that perhaps, political speech and other things, but certainly speech that kind of hits them where they live, I think has been an important thing.
And I will just say one more historical incident that is close here physically, and that's the deaf president now at Gallaudet in the 80s that pushed for a deaf president of Gallaudet University. So literally disability is in everyone's backyard and even in front yards. So I do think that there needs to be more engagement with actual work by disability advocates and giving them a little bit more credit.
So one of the things I noticed or picked up on in both, Bob, your comments, but Duran's comments as well, is that you don't think that the paper necessarily provided sufficient evidence that people with disabilities might refrain from speaking, and that people without disabilities might be more guarded in speaking with them because the environment's not sufficiently pro-free speech, or it's not a free speech culture. What kind of evidence would you like to see? Is there something that would convince you, or what does that look like?
Yeah, so I think a couple of different things. First of all, obviously being in conversation with, having relationships with people with disabilities. One thing that we often say about people with disabilities is many of them have only two kinds of people in their lives, family and those paid to be there. They don't necessarily have the range of friendships and other kinds of acquaintances that others do. So one thing would be just to be, to insert yourself and to be in environments where you run up against and hear people. Because again, some of the most interesting things I've learned over the years have been just things said to me in a meeting or waiting for a meeting to go on and giving me an insight that I wouldn't have otherwise had. Also, of course, one can conduct interviews of people and kind of reach out and work with some organizations that have access to people with disabilities, so you can get a sense of what's on their mind, what they're thinking about, and that even beyond that, surveys of things like that. So I do think there is a danger here of operating through anecdote. I think we do need data, and data, has certain characteristics of it for it to be meaningful and to be sustainable. And I think that's one place where I think I might go. Maybe not in this paper, but maybe as a part of a broader project, which I know Ruben is interested in.
Do you have anything to add, Duran?
No, I think that's.
Okay, well, then I'm going to actually draw upon some of your expertise. And could you just, for those of us not as familiar, could you talk about the nature of reasonable disability accommodations, at least in the U.S., and how that theory and doctrine relate to Ruben's paper?
Yeah. I think that's what kind of Bob alluded to by this concept of anticipatory accommodation. Like in the U.S., in order to get a disability accommodation, a person actually needs to come out and say that they are disabled. And I think that is something that might surprise a lot of people because it seems like something that is very private and something you might not want to disclose. What disability advocates would say is that disabilities might not be a bad thing. It might be a good thing. It might be a life-enriching experiment. It might be a source of pride. So if you look at it that way, the disclosure might seem a little different. But anyways, you do need, as a person with a disability, to come forward, as a person with a disability, say what the accommodation that you need should be, and then the employer would know and would know how to accommodate you in the future. So it is something that is not anticipatory as it might be in other legal systems. I'm originally from Israel. The Israeli system is very similar to the American ones, but the Anna Lawson article that you cite, Ruben, here, I think I learned a lot from it too. So I didn't only wanted 90 pages. I actually went and read other papers as well. I think Bob as well. But I think it's, again, I think here, the individualistic nature of a disability is also very important. So I write a lot about masking as disability accommodations. When I talk about masking as disability accommodation, I don't talk about universal masking mandates. I don't talk about that. What I do talk about is that if there is a person with a disability that sits in a specific environment, the people around them specifically might need to mask to accommodate them. So to me, a free speech, a policy might not fit as well with the issue of accommodation in that respect either, and it might be thought of more of as a defense, kind of like what I alluded to in criminal law.
Thank you. Well, and that actually brings me back to you, Ruben. So one of the things, the main thrust of your paper is that you're proposing a free speech culture as a reasonable accommodation, which would, at least as put forth in your paper, severely limit sort of harassment or hostile environment policies currently in place. So to put you on the spot a little bit, isn't that kind of radical?
I wouldn't say it is. I think those hostile environment laws, they came from a very different time and a very different set of circumstances. And what has happened is governments have kept expanding the definition of harassment, right, to extremely large number of characteristics, extremely large number of rights to be not offended. Whereas what they haven't done is dealt with the root cause. So this is like a sideshow. They haven't dealt with the root cause, which is abuse of power, abuse of basically disparity in power relationships. So, for example, you put proper protections in place, so they couldn't, for example, not hire you because you complain about harassment or you've made any other type of whistleblowing type complaint. Then you probably wouldn't need all these expanded provisions. So it's the concept. What's happened is that these concepts have been indefinitely expanded as a way of avoiding dealing with the issue. The other thing is that just because disabled people came last, why should we not start at the beginning with all these provisions? These provisions came about before there was a Disability Discrimination Act in the United States, which was the first one, by the way, in the world. These provisions came about before there was a concept of neurodiversity. They came about before we could see the ways people could be cancelled today. So they're from a very different time. They should be reconsidered. There's nothing radical about it. It's about rethinking very carefully about whether the right balance has been struck. And it's worth remembering that there's an underlying assumption under international human rights law, under most disability law, the idea of reasonable adjustments, right? They apply to one group, disabled people. They don't apply to any other group. There's maybe some small ones for religion, but not anything like in the same way it is with disabled people. And there's a whole concept of treating disabled people more favourably. So, the people who may want to be not offended, today they can work from home. There isn't the same sort of issue or motivation that you'd have as there were, you're locked in a workplace with people 50 hours and they could say what they wanted to you, right? It's a different world, it's a different time. And so there's nothing radical about, having the courage to say, actually, let's think about things in a disability context. Let's think about the world we are in now. Let's think about those sort of rules that would work. And discrimination law has always been a compromise. It's always been a messy compromise. It's always been a compromise that often hasn't worked. It would be radical to keep things the same in a certain way. It would be, because this is what we've always done, because they were there first. I don't think it's that radical, but I do think it's something that some people will go, oh, but these protections already exist, we shouldn't go back on them. But actually, those protections don't work. They undermine discrimination law because they bring it into disrepute in a way. So that would be my roundabout answer to being put on the spot, as it were.
I want to go to audience Q&A, but first I want to get my other respondents.
Just really briefly, I think the big issue in employment is the significant and severe and long-standing underemployment of people with disabilities, notwithstanding the 33 years we've had the ADA and other things. So I don't actually think there's much concern about whether hostile work environment rules or policies are somehow limiting people with disabilities. The problem is we can't get them into the workplace in the first place.
I would like to open it up to audience questions. I see one right there. David?
Yeah, hi. I'm wondering if part of it, I'm not sure if it's a disconnect or part of the issue here, is that Ruben is talking about disabilities from an international context, and we have two American commentators, and I was checking my instincts on this. So the International Human Rights Convention on Disability defines disability as someone with long-term physical, mental, or intellectual or sensory impairments, which in interaction with various barriers may hinder their full and effective participation in society on an equal basis with others. Now that would include, as it does, it seems in the educational context at least, but not in the employment context in the U.S., things that are relatively mild intellectual disabilities, like having significant but not, ADHD, not that you can't sit still at all, but you have ADHD and that it may make you impulsive, or it might include having mild autism, which then we go to the American, which I'm sure everyone's familiar with, but I just lost it, here we go. The American ADA rule is that disability is a person who has physical or mental impairment that substantially limits one or more major life activities. So that would not include
There's two more prongs to the
Okay,
ADA.
well, I'm not a disability guy. So
Yeah, you can tell.
But it does seem, I've seen this elsewhere because I saw some scholarship when I was looking through scholarships for my daughter. She said, like, international institutions said they use a much broader definition. No? Maybe?
No.
Yeah,
No?
and actually, the language you first quoted, technically, that's the CRPD, the Disability Treaty, does not actually define disability. It really defines characteristics of what a state should do. The ADA definition is pretty consistent with actually the way it's interpreted. There are ways in which the CRPD, which I have done some work on, is interpreted differently from some of our laws, and in particular, and this is through interpretations that the committee of experts that reviews the treaty have pushed, which is disability should never be used as a way to distinguish people in different circumstances. I actually think in some ways that goes too far. But so it's really looking at and saying, everybody has capacity, everybody should be treated equally, there should be no carve out, even in situations where we might think like, competency to stand trial or insanity defense where there is relevance to the disability, which is my own view, which is that we should be very careful. We should take disability into account where it makes sense to, and we should not do so when it doesn't. And historically, society has too often taken it more into account than it ought to in negative ways. So anyway, I don't think it's there is some, again, I think that on the issue of anticipatory discrimination, that is a difference between, and I don't necessarily think Australian law, but it looks like at least UK law, and Norway, I think was the other country, and US law on that side.
And if I can add, there is something that kind of, I don't know, you correct me if I'm wrong, but in the IDEA, the Individuals with Disabilities Education Act, there is a requirement for schools to locate students with disabilities.
Right. So-called child find. Yeah.
Exactly.
Yeah.
And that could be considered, supposedly, an anticipatory disability because you do have a requirement to go and look for people.
Right.
That is the most, and I think that's why you know about it from your, like maybe, that's kind of like what you mentioned. And to me, that is not an accommodation per se. It also has to do with education in particular. And I just want to emphasize, because you brought up the definition of the ADA for disability, that the third prong, it protects people who are regarded as a person with a disability, even though they don't have one. That shows you how disability is a relationship between the environment and the impairment.
You could go. I just want to get like a concrete. I'm just curious, like a concrete case. Let's say there's a guy who has explained that he has some mild social disability where he has trouble reading, maybe autism, something else, where he has trouble reading signals, and he informs his employer. Several women at complain that he's acting creepy towards them. And why is he acting creepy? Well, he says certain things. They clearly express, they express what they think is clear discomfort, and he doesn't stop. And they fire the guy. Now, he doesn't have that major life thing. Like he could hold a job, he could work, but he does have the. Would that potentially be a defense under American law that he didn't get a reasonable accommodation?
Absolutely. The answer is absolutely. And the definition of what is a major life activity is including walking, speaking, sitting, working. So it's a very broad definition.
But you do bring up implicitly something that I think is really a challenge in disability law, and that is the individual nature of it. Because, for example, what you couldn't do as the employer is to take those female employees aside and say, he has a disability, so, cut him a break. And that doesn't mean they have to, but you cannot disclose that because that's a matter of privacy for that person. And so even, whether it comes to, there's cases regarding a unionized workplace and sort of, well, why is someone getting seeming preference to get a position that otherwise is subject to seniority? Well, maybe because we need to do that to accommodate that person, but you can't really say that. So I've thought about that and how to deal with that, and my way of dealing with it, which is not perfect at all, would be outside of the context of any particular person. Maybe this is in your employment manual or something, and to say, look, there are things we're going to have to do with regard to different employees. We have to follow the various civil rights laws we have. Please, if something looks to you like, oh my gosh, this person's getting special treatment, recognize that there may be reasons why they're doing that, and we can't say more about that. It doesn't mean that's always going to be true, but I think it does at least give some sense that somebody who has flexible work hours isn't just necessarily getting a benefit because the supervisor is sweet on them, but because they may need that as an accommodation for treatment that they're getting.
And may I recommend a paper for you on that exact topic, and that is by Adi Goldinel, and it's called Moral Accommodations, and I'm not sure if it's out yet, but if it's not, email me and I'll send you a copy, because I was commenting. Yeah,
Yes.
and it has it in my notes.
Ruben, did you want to comment on that?
I mean, I think that I don't think the differences lie mostly in definitions. I think they lie in the context, right? The US context is very different to any other country. You can fire people at will in the US most of the time, right? You don't have the same privacy rights. So I think the definition of disability, it's not the main effect in this case. It's actually the process. So, the category of disabled people that are protected in the UK is not widened by the definition. It's widened because they don't have to actually do anything to enact this protection, right? If I act a bit odd at an event, right, that's constructive knowledge, right? Or, for example, you'd expect there'd be a ramp here for someone who is a wheelchair user, right? The wheelchair user wouldn't have to ask. They come here and so on and so forth. And then if they couldn't access it, then they can claim, right? So I think that the distinction actually lies around all the other rules. And the other system. The US is a very different society compared to other societies that I've lived in. So I think, even under the UK, though, 20% of disability discrimination claims get thrown out because they find some sort of definitional excuse. And that's more to do with the general approach towards disability discrimination claims and also discrimination claims. Like they try to find jurisdictional wheezes to get out of actually dealing with the issue. And that's something even the former president of the UK Supreme Court was saying, Lady Hale, that basically they come up with all these different ways around it, or they go as far as basically trying to avoid certain questions. So you have to see the system as a whole. I think definition's one thing. I mean, another interesting distinction actually between the US and Australia and say the UK is that there's no time limit to become disabled, right? So in the UK you have to basically be expected to have the condition for at least a certain period of time, whereas if I break my arm tomorrow in Australia, right, now I'm disabled for purposes of the law, right? That may only, I'm probably not going to be discriminated against for it, but I still fit in the category. And turning to the case you were talking about, that actually happened in Australia. There was a university professor called Aaron Harwood, and he said some inappropriate things, and then of course they went and got him for that 6 years later. It wasn't fair the way they went after him, right? Because they basically tricked him into deciding confession, and they also didn't take into account his condition, or they didn't take into account that he could, for example, just do research work and be left on his own. And in the UK, we had a case, I think it was called Burdett versus Aviva Insurance. This is where a schizophrenic person went in and sexually assaulted several female staff members, and the Employment Appeal Tribunal, so the equivalent of the High Court in the UK, so probably the equivalent of, say, having something heard in the circuit court here for employment matters. That went as far as basically saying that he should still be employed, or they should consider still employing him because he could work from home, and that was before the pandemic. So it's these cases, every case is on the same merits, but it's a mess, right? It's not just the definitions; it's people willing to apply the law, people avoiding applying the law. Discrimination law probably, I would say, is as close thing to pseudo law that's within the law as anything, because the judges don't follow it. There's so many ways it's tortured and expanded, but it's still within the law. But it's not normal law. It's not predictable. People don't follow it in the way you'd expect. It's a very unusual area of law, and disability discrimination law is even more so with the concept of reasonable adjustments, which of course doesn't actually mean what it says. People think it means reasonable, right? You tell a layperson about reasonable adjustments, they think, oh, I feel this is unreasonable, I don't have to do it, right? It's objective reasonableness, and it's a test that's really an economic cost-benefit analysis dressed up. It's an unusual one.
Yeah, I think we have time for one more question. Oh, Emerson.
Thanks. I'll try to keep it quick. I know we're running low on time. I just wanted to, having not had the benefit of reading the paper, but just seeing the list of recommendations, I just wanted to sound a note of caution on the recommendation that Joanne pointed out on the hostile work environment. I work on First Amendment and race, and so the bumping up against of discrimination law and free speech law is something that I'm very intimately aware of, and so I am critical of lots of the harassment laws and employment laws in the ways that many free speech folks are. And I just want to push back on the idea that the development of the hostile work environment and harassment laws was avoidance. That's one frame, but I also think it was actually trying to be inclusive and maybe overly inclusive rather than avoidant. And I think it was trying to address a specific problem, which is the ways in which people can feel unwanted and unwelcome and precluded from participating in ways that are not necessarily explicit or easy to define, right? So hostile work environment tries to get at all those other sort of environmental ways, literally, that these things can happen short of actual, firing, discrimination, employment action. So I just think that if you're going to suggest that it should be done away with, I think we need to give a little bit more charitable notion to what function it actually is playing.
My argument is it should be heavily narrowed and reconsidered. Starting from the beginning with something like that. It certainly doesn't work for disabled people. And in fact, the hostile environment law, I think, would have the worst effects on how other people would treat disabled people, because the memiplex around terms around disability, right? There's some groups that list is actually quite small. Disability is enormous. And then there's also the behaviours and so on and so forth. So you try and apply that. It's probably something that massively keeps disabled people out of the workplace, because people think, goodness, why do I employ that person when they're going to create this whole potential environment, and then people don't want to engage with them, that sort of thing. It had a purpose when it's, I think it was legitimate when it came back in the 80s, but today's world, we're 40 years on, it needs a whole rethink, and it's also, it does avoid, particularly in the US, that people can fire you for some other reason, right? So if you didn't have, the worst abuses are abuses of power, right? People saying, I won't give you that reference if you don't do this to me, right? Those sort of cases, that was what harassment law was originally about, and then it got expanded and expanded and expanded, and without actually dealing with that fundamental issue of power disparity in the workplace and power disparity in other environments. People could be a lot more comfortable if they had freedom to leave, or freedom to move on, or freedom, weren't made to go to do things. I think that, but back in the day, was for 50 hours stuck in a room or something, I can see that that's a very different environment to having to have a conversation on Zoom when you can pretend to listen to them and have a cup of coffee, right? Today's world's so different. I think it's worth revisiting it. And obviously, I've just proposed looking at it, not actually so far as it should be narrowed, but exactly how. That's a book. I think I've been told for writing too many words. I know lawyers used to be paid by the word, but I think that's a story for another day.
Well, we are out of time. Thank you. This has been very thought-provoking, so I've really enjoyed it. Hopefully you all did too. And we do now have a break until 3 o'clock.